everybody, and welcome to Legal Studies Unit 3, Area of Study 2, the Civil Justice System Part 2. The focus of today's video is dot points 3 and 4, factors to consider when initiating a civil claim, including negotiation options, costs, limitation of actions, the scope of liability, and enforcement issues, and the purposes and appropriateness of Consumer Affairs Victoria and the Victorian Civil and Administrative Tribunal in resolving civil disputes. Factors to consider when initiating a civil claim. Negotiation options. Negotiation can be conducted outside of a courtroom or tribunal. The parties discuss a way forward and try to resolve the dispute at hand themselves. It is the least costly way to resolve a civil dispute. Legal representation can be used. An independent third party may also be used, for example, a mediator to facilitate the discussions or a conciliator to provide suggestions to the parties. Some of the benefits of negotiation include that it is cost effective. The parties also have control over the outcome. The parties are more likely to be satisfied with the outcome since they have a say in reaching it, as opposed to a third party enforcing it upon them. And it is beneficial to parties who wish to foster an ongoing relationship. Some of the limitations are that negotiation is voluntary, meaning that one or both parties may not be willing to negotiate. One or both parties may want their day in court. They may have a win or lose mentality. Costs. Parties need to consider the costs and possible financial consequences if they are unsuccessful. Parties need to consider the cost of legal practitioners. This can be particularly costly depending on the complexity of the case, the court where the case will be heard, the length of the proceedings, and the expertise of the lawyer. Victoria Legal Aid can offer some assistance in civil matters. The assistance, however, mostly goes to criminal matters, since there is no need to sue and there are alternative ways to resolve civil disputes. Adverse costs. If the plaintiff is unsuccessful in their civil action, they may be ordered to pay some of the defendant's costs. The successful party should receive an order form from the court that their costs are paid by the losing party. This cost could be enough to deter a plaintiff from initiating a civil claim. Disbursements. Court fees. There are filing fees. There are court fees for the Magistrates Court, County Court, Supreme Court, and the High Court, which are listed below. There are also jury costs. The party who requests a jury must pay this cost. The daily jury fee is between $550 to $1,000 depending on how long the trial is. The limitation of actions. The limitation of actions is the time period that the plaintiff has to commence proceedings. If the time period is exceeded, the defendant can raise a defence that the plaintiff has taken too long to bring the claim. The limitation of actions ensures that disputes are dealt with in a timely manner. It ensures that evidence is still reliable, as delays can limit the reliability of evidence. And courts have the discretion to extend time limits if they believe it is just and reasonable to do so. Some civil claims have no limitation period. For example, actions alleging death or personal injury resulting from the physical or sexual abuse of children. The limitation of actions for defamation is 1 year. Claim in tort or contract, 6 years. And personal injury, 3 years. The scope of liability. The plaintiff must prove that the defendant is liable. In determining the scope of liability, the following are to be considered. Causation, that is, was it the defendant who caused the harm? The remoteness test, was the harm a direct result of the act? And reasonably foreseeable, could the defendant have known that the act could cause harm to the plaintiff? Extent of liability. The defendant can argue that they are only liable for part of the harm caused. The defendant may alternatively argue that somebody else entirely caused the harm to the plaintiff. Enforcement issues. Despite a successful court action, the plaintiff may not be paid the amount awarded to them. This is dependent on the defendant's ability to be able to pay and if they will actually pay. If the defendant does not or cannot pay, the plaintiff may have difficulty collecting the judgment. The court is able to enforce an award of damages by ordering a warrant for distress, an attachment of earnings, bankruptcy and liquidation, or imprisonment. Purposes and appropriateness of CAV and VCAT in resolving civil disputes. Consumer Affairs Victoria is a business unit of the Department of Justice and Community Safety within the Victorian Government. Its purpose is to help Victorians be responsible and informed businesses and consumers. To achieve this purpose, CAV review and advise the Victorian Government on consumer legislation and industry codes, advise and educate consumers, tenants, businesses and landlords on their rights, responsibilities and changes to the law, register and provide licences for some businesses and occupations, conciliate disputes between consumers and traders and tenants and landlords, and enforce and ensure compliance with consumer law. Looking at Consumer Affairs Victoria's jurisdiction, they can only assist in settling disputes in areas within jurisdiction. Consumer Affairs Victoria obtains its jurisdiction through Victorian statutes and can assist with disputes about the supply of goods and services, residential tenancies, retirement villages, and owners' corporations. Resolving a complaint. The method of conciliation is used. It is usually conducted over the phone, which is beneficial if parties are not in close proximity of one another. The conciliator will outline the rights and responsibilities of the parties and suggest a reasonable outcome. Participation in conciliation is voluntary, meaning that Consumer Affairs Victoria cannot force parties to participate. This may be a limitation if one party is not willing to participate. And Consumer Affairs Victoria cannot make a binding determination in the dispute. VCAT is a tribunal that resolves disputes and makes decisions about human rights cases. There are over 46 venues across the state, and VCAT's vision is to serve the community by resolving disputes in a timely, cost-effective, and efficient way. The purpose of VCAT is to provide an alternative to court for resolving some civil disputes. The VCAT website states that VCAT is deliberately less formal than a court and encourages parties to represent themselves where possible. Looking at the VCAT jurisdiction, they can assist in settling disputes in areas of legal, practice, planning and environment, review and regulation, civil claims, building and property, owners, corporations, guardianship, including power of attorney, human rights, and the residential tenancies list. Alternative resolution services include a confidential meeting where parties can explore options to resolve their dispute with the help of an impartial mediator or VCAT member. This can be done through mediation, compulsory conferencing, fast-track mediation and hearing, and that's for resolving goods and services disputes up to $5,000. If a party does not attend mediation or a compulsory conference, VCAT can make an order against them, including making an order against the absent party, striking out the application made by the absent party, removing the absent party as a party in the proceeding, or make an order for costs against the absent party. That concludes today's video on Unit 3, Area of Study 2, Part 2. I hope your knowledge of dot points 3 and 4 have been consolidated. If you do have any questions, feel free to email me or leave them in the comments below. Thank you.